too well, but apparently yours are working very well, so just be alerted to that, anything you say may well be broadcast. Question number 10, Charles Chauvel.
Thank you, Mr. Speaker. My question is to the Minister for Courts and asks what decrease, if any, in the use of the family court after 1 July is expected to result from his decision to introduce fees of $700 plus a daily hearing fee of $1,812 for applications for divisions of assets and fees of $220 for childcare disputes, both of which applications are at present fees-free.
The Honourable Chester Borrows.
Mr. Speaker, in answer to the question, based on last year's modelling, there were 18,000 applications before the court which would be liable for the payment of fees. About 8,500 of those are in respect of childcare disputes, and about 1,700 in respect of property disputes would be, about 8,500 childcare disputes and about 1,700 property disputes would be expected to pay the fees, and the balance would be expected to avoid the fees either by applying to the registrar of the court for a waiver, of which there's expected to be a significant number granted, or by finding some other way to sort the dispute and not come to the court.
Charles Chauvel.
Thank you, Mr. Speaker. What advice, if any, has he received on the risks to vulnerable children of introducing user pays to a system that was deliberately designed to be fees-free in order to ensure that such children did not suffer as a result of the inability of their parents to pay a fee when trying to access the court?
The Honourable Chester Borrows.
Thank you, Mr. Speaker. It's important to note that family violence matters such as seeking a protection order do not require fees, and that those applications will be lodged free of charge as they are now.
Chester Borrows. Beg your pardon, Charles Chauvel.
Thank you, Mr. Speaker. What consultation took place with family court judges prior to his announcement that these fees would be introduced, given that the Dean of the Otago Law School said on the 9 to Noon show this morning that he'd been told on Sunday by a family court judge that the family court judge was unaware of this decision until today?
The Honourable Chester Borrows.
I'm unsure why the commentator would make that comment, bearing in mind that in September last year it was flagged that these fees could well be introduced ahead of the family court review being completed. I'm unsure of precisely what consultation was made with family court judges, or specifically which family court judges were consulted with.
Charles Chauvel.
Thank you, Mr. Speaker. Who is correct? Judith Collins, when she said on the 27th of February that it was important to await the outcome of the family court review before progressing important decisions such as those around the Legal Aid Sustainability Bill, or he himself when he said on Morning Report this morning in respect of his decision to introduce these fees well before the outcome of the family court review is known, quote, "Quite honestly, if we kept waiting and waiting, we'd never get anything done," end quote.
The Honourable Chester Borrows.
The point is, of course, that people who are subject to these fees liability do not have to come before the court. There is always the opportunity of them getting around the table with their lawyers or other advocates and being able to sort these matters out without having to go through to litigation. There is no question of an access to justice issue here, because those opportunities are open to them. I don't believe that the Minister's statement and my statement are mutually exclusive.
Question number 11, Jan Logie.
Thank you, Mr. Speaker. My question is to the Prime Minister.